Hello, and welcome to Week 5 of the course, International Human Rights Law Prospects and Challenges. Today, we'll look at a variety of mechanisms for implementing, monitoring, and enforcing human rights at the national level, meaning in national legal systems. Let me identify for you a number of overarching questions that we will consider this week. So first, I would say the broadest question is, what are the benefits and costs, or the advantages and disadvantages, of protecting and promoting human rights using national mechanisms in domestic legal systems? We'll see that domestic mechanisms are closer to the location of the violations, to the victims of those violations, and in many cases to the perpetrators, and as a result they might be able to provide more effective and speedier justice. Another question that we'll consider is what accountability mechanisms exist with respect to human rights violations committed by a prior regime, usually a military dictatorship or autocracy, when the new government of that country comes to power. The issues we'll consider here are how to deal with a legacy of violations by officials who are no longer in office, and with respect to a country that is attempting to move on from brutality and violations of the past. A third overarching issue that we'll think about is wonder what sorts of circumstances may the government of one state criticize the government of another state with respect to human rights issues. A number of countries, as we will see, report on the human rights progress of other countries, and in addition impose sanctions or withholding of aid in the case of violations of fundamental rights and freedoms. This, as you can imagine, might create a number of challenges when the target country of those sanctions or aid withholdings feels that the country reporting or sanctioning it also engages in human rights violations. And finally, we'll consider when the courts in another country can entertain criminal prosecutions or civil damage actions with respect to human rights violations that occurred in a different country. And here the question that arises is whether it is appropriate and desirable for a country that has little or no connection to human rights violations in another state to entertain such proceedings. The answer to that question may turn on the availability of remedies in the national legal system where the violation occurred, and it may also turn on different normative conceptions about the universal applicability of certain human rights norms. Let's turn to a specific overview of the topics that we'll discuss in Week 5. First, we'll look at mechanisms for promoting and protecting human rights at home, that is, in the country where the rights violations occurred. We'll begin by looking at accountability for past human rights violations, the violations committed by a previous government and its officials. The alternative here is between criminal prosecutions and truth commissions, although a number of countries have used both of those mechanisms, and we'll discuss the pros and cons of each. We'll also consider the issue of litigating human rights cases in domestic courts, and the more recent development of national human rights institutions. These are governmental bodies that are charged with promoting and protecting human rights at home. In the second half of Week 5, we'll turn to national mechanisms to promote and protect human rights in other countries. The issues we'll discuss here include country reports by one country with respect to the human rights conduct of another, financial assistance and sanctions, and the concept of universal jurisdiction to bring suit in another country's courts for violations that occur elsewhere. I hope you will find these issues to be as interesting and in some cases challenging as I do. I'll leave you with this slide, which provides a number of sources that give additional background and information regarding these topics.